Welcome to EUPrivacyForAll, Session 2 on the final draft of the GDPR published in May, Articles 6(1)(a), 7 and 8 on consent. The GDPR final draft published will be the basis of this study, and blue case will show the last range of modifications. There was no renumbering on Articles 6(1)(a), 7 and 8 on lawfulness of processing, conditions for consent, and conditions applicable to child's consent in relation to information society services. Articles 6, 7 and 8 are the key provisions framing consent in the GDPR. In Article 6, it is made clear that data subject's consent will be the first ground to demonstrate a processing is lawful. In Article 7, on the conditions for consent, it is reminded that the controller shall be able to demonstrate that the data subject has consented to the processing of his or her personal data. If the data subject's consent is given in the context of a written declaration, which also concerns other matters, the request for consent shall be presented in a manner which is clearly distinguishable from the other matters, in an intelligible and easily accessible form, using clear and plain language. The data subject will have the right to withdraw, and it shall be as easy to withdraw consent as to give it. Finally, in paragraph 4, it is stressed that when assessing whether consent is freely given, utmost account shall be taken of whether the performance of a contract, including the provision of a service, is made conditional on consent to the processing of data that is not necessary for the performance of that contract. Article 8 specifically targets the child's consent in relation to information society services. There is a possibility for the child to consent when being more than 16 years old. Where the child is below the age of 16 years, such processing shall be lawful only if and to the extent that consent is given or authorized by the holder of parental responsibility over the child. And let's recall that member states will have the possibility to provide by law for a lower age, retaining that such an age cannot be lower than 13 years old. The controller shall make reasonable efforts to verify in such cases that consent is given or authorized by the holder of the parental responsibility over the child. And paragraph 1, that is to say, this threshold shall not affect the general contract law of member states. Let's share here a caveat stressed in recital 29. The consent of the holder of parental responsibility should not be necessary in the context of preventive or counseling services offered directly to a child. Further guidance could be needed here. A key recital in the GDPR is recital 32. Consent should be given in a clear affirmative act establishing a freely given, specific, informed, and unambiguous indication of the data subject's agreement to the processing of personal data relating to him or her. It could be done by a written statement, including by electronic means, or an oral statement, or ticking a box, or also choosing technical settings for information society services, or any other statement or conduct. Silence and pre-ticked boxes or inactivity could not be considered as giving consent. Consent should cover all processing activities carried out for the same purpose. And when the processing has multiple purposes, consent should be given for all of them. Whenever required by electronic means, the request must be clear, concise, and not unnecessarily disruptive to the use of the service for which it is provided. In the frame of scientific research purposes, as reminded by recital 33, consent could be given to certain areas of scientific research or parts of research projects. Recital 40 recalls that data subject consent is one of the first legitimate bases for processing personal data. Recital 42 lays down that where processing is based on the data subject's consent, the controller should be able to demonstrate that the data subject has given consent. The safeguards should be ensured so that the data subject is aware of the fact that and the extent to which consent is given. As laid down in the Directive 93/13, a declaration of consent pre-formulated by the controller should be provided in an intelligible and easily accessible form using clear and plain language. Consent, finally, should not be regarded as freely given if the data subject has no genuine or free choice or is unable to refuse or withdraw consent without detriment. In Recital 43, in order to ensure that consent is freely given, consent should not provide a valid legal ground where there is a clear imbalance between the data subject and the controller. For instance, whenever the controller would be a public authority. Consent, in this case, will not be presumed to be freely given if it does not allow separate consent to be given to different personal data processing operations, or if the performance of a contract is dependent on the consent, despite such consent not being necessary for such performance. As set in the new wording of Article 4.11, the definition of consent is any freely given, specific, informed, and unambiguous indication of the data subject's wishes by which he or she, by a statement or by a clear affirmative action, signifies agreement to the processing of personal data relating to him or her. Let's focus now on the fact that in 3 cases, as per the GDPR, explicit consent will be required. First case corresponds to Article 9.2a, processing of special categories of personal data. That is to say, personal data revealing racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union memberships, genetic data, biometric data, or sex life and sexual orientation. The second case is the one laid down in Article 22.2c, that is to say, automated individual decision-making, including profiling. In a third case, explicit consent will be required, the one of data transfers in the absence of an adequacy decision or of appropriate safeguards. In Article 2H of the Directive, 3 of the 4 parameters laid down in GDPR appear to be defining data subjects' consent: freely given, specific, and informed, but unambiguous is missing. We will find unambiguous in Article 7a on the data subjects unambiguously giving consent. Also in Article A2a on explicit consent being required regarding the processing of sensitive data, and 26.1a on data transfers in a country not ensuring an adequate level of protection, we will find some of the provisions in GDPR. What should accountable data controllers get prepared for? First, they should know that consent remains the or one of the key legal grounds to process personal data. They should identify when it is necessary to collect an ambiguous or explicit consent. In 3 cases, explicit consent is required by the GDPR: the processing of special categories of data, profiling, and data transfers that are not framed by adequacy decision or appropriate safeguards. Controllers will have to make it clear that it is as easy to withdraw consent as to give it. Consent will have to be considered given only if the request is clearly distinguishable from the other matters, intelligible, easily accessible, and clear and plain language is used. Controllers will have to demonstrate that the data subject has consented, that is to say, keeping tracks of the documentation. Specific consent will be requested for each single purpose of the processing. And finally, no contract will be made dependent or conditional on unnecessary consent, that is to say, on processing data that are not necessary. Under 16 years old or down to 13, depending on national laws that will be adopted, consent shall be given by the holder of parental responsibility when it comes to a child. Controllers shall make reasonable efforts online to verify the age of the data subject consenting. So the question triggered now is knowing whether member states will coordinate, for instance, on the threshold regarding child's consent online, and what will be the Working Party 29 and European Data Protection Board guidance.